How to use Debt Relief Canada COVID to achieve the benefit of more time. Debt Relief Canada COVID Introduction. I have written before many blogs about debt relief in Canada and Debt Relief Canada COVID. I have written about personal insolvency, debt settlement, consumer proposal, Division I proposal, bankruptcy, corporate insolvency, bankruptcy protection restructuring, both under the Companies Creditors Arrangement Act, Canada, and the Bankruptcy and Insolvency Act, Canada. Receivership, liquidation, bankruptcy, Debt Relief Canada COVID specific, personal insolvency, corporate insolvency, Office of the Superintendent of Bankruptcy, OSB, going to court in every province to get timelines extended. Now the federal government has drafted legislation to guarantee that Canadians, as well as Canadian companies, have the ability to meet governing timeframes and target dates found in federal statutes. Some key target dates for Debt Relief Canada COVID found in the BIA and other statutes, such as the Canada Labour Code, given the COVID-19 pandemic and the courts essentially being shut down and only hearing emergency matters. In this Brandon's blog, I discuss the proposed Time Limits and Other Periods Act, COVID-19. The purpose of this proposed statute will aid Debt Relief Canada COVID. Canadian Department of Justice concerns. On May 19, 2020, the Canadian Department of Justice unveiled draft legislation. The government has posted it online and is allowing 10 days for any comments to be submitted on the proposed Time Limits and Other Periods Act, COVID-19. The federal government is concerned about Debt Relief Canada COVID and all other issues federal legislation deals with. As I previously wrote, the OSB went to court in each province to get certain deadlines suspended so that debt relief in Canada would not suffer. The OSB ensured that the system would work for Debt Relief Canada COVID. The federal government believes that so many Canadians, as well as Canadian companies, could be impacted in other federal statutes not designed for financial restructuring or debt settlement. The government is concerned that they may encounter possible legal jeopardy if, due to the COVID-19 pandemic, they fall short to meet target dates. Consequently, the Government of Canada published draft legislation, which outlines prospective remedies that the federal government might apply to deal with these essential problems. The draft legislative proposal for dealing with Debt Relief Canada COVID is online for 10 days. Interested stakeholders are invited to share their comments by May 29. What the draft legislation is designed to do. The draft legal proposal is designed to suspend specific timeframes as well as enable government ministers to prolong or put on hold other time limits consisted of in government regulations to ensure that Canadians, as well as Canadian companies, are able to satisfy governing timeframes and deadlines found in federal statutes, such as some key due dates found in the BIA for Debt Relief Canada COVID and under the Canada Labour Code during the coronavirus pandemic. Protect Canadians' rights and access to justice in the context of civil proceedings before the courts, by making sure that people and companies are protected to assert their rights and not miss a time limit or deadline during the COVID-19 pandemic. The draft legislation includes stipulations to make certain that short-term extensions or suspensions cannot be made after September 30, 2020, and could be retroactive to March 13, 2020 when the COVID-19 pandemic officially began. What the draft legislation says. As already mentioned, the draft relief is designed to protect Canadians under federal statutes designed for Debt Relief Canada COVID and other federal laws. So here are the highlights of what the draft Time Limits and Other Periods Act, COVID-19, currently proposes. Section 3 defines a time frame. It says such time periods that are either suspended or prolonged under this act, then, during the period that the suspension or extension holds, every mention in any Act of Parliament to that time restriction or duration is to be read as referring to the time limit or period as it is suspended or expanded. Section 4 states that the Act does not refer to any time frame or any other duration related to the investigation of an offence or a proceeding arising from an offence. Sections 6 and 7 deal with time limits related to proceedings. The proposed legislation purports to put on hold, as of March 13, 2020 as well as until September 13, 2020, or an earlier day set by the Governor and Council, certain time frames certain proceedings, aside from proceedings from offences, before the courts. Allow courts to adjust the suspension within particular limits and take measures regarding the results of a failure to satisfy a put on a hold time limit. Allow the Governor and Council to waive such suspensions in particular scenarios. Permit ministers, in respect of defined regulations, to put on hold or prolong time limits and also prolong other durations for no greater than 6 months, as well as to offer such suspensions or extensions retroactive to March 13, 2020. A time frame might be put on hold or extended, and also a time duration might be expanded for a total maximum period of 6 months. Permit ministers in the case defined in the previous point to give specified persons, bodies or tribunals some adaptability in applying these suspensions or expansions. Prevent these powers from being exercised after September 30, 2020. This draft act would certainly permit the Governor and Council to restrict or enforce conditions on the powers provided to ministers. Having a federally mandated timeout will certainly aid Debt Relief Canada COVID.